Hello, YouTubers. This is Kelly Blatnik with Blatnik Law, LLC. Feel free to check out my website, www.blatniklaw.com, BLATNIK law.com. I'm going to briefly discuss responsive pleadings. In the state of Nevada, when you're being sued, you have to serve a responsive pleading within 21 days. That is Nevada Rule of Civil Procedure 12A1A I. And what that means is within 21 days. And currently, every single day is a blessed day, so you count weekends and holidays and everything. The only time you get an extension is if the last day of those 21 days falls on a weekend or a holiday, then it's the very next day that the court is open. What is a responsive pleading? Responsive pleadings can include a lot of things. An answer, a motion for a more definitive statement, a motion to dismiss, an answer and a cross-claim, an answer and a counterclaim, an answer and a third-party complaint against someone else. The important thing is to remember, although it says within 21 days, just think you've got about 21 days to respond. And I always like to tell people, think 20 days so that you will do it on time. Don't ever wait till the last minute to do responsive pleading. And the responsive pleadings I listed are not all inclusive. An answer is something that simply responds to the complaint, saying admit, deny, or without knowledge. Those are essentially the three choices that you get for each discrete paragraph. An answer and a counterclaim is admit, deny, without knowledge as to the complaint, and then say, wait, you did stuff wrong. You owe me money. I don't owe you. So that's a counterclaim. A cross-claim is when there's more than one defendant and one defendant files their answer to the complaint, meaning admit, deny, without knowledge, are the three choices that you have, and then says, but you know what, defendant B, it was really their fault, and so defendant B needs to pay me for certain damages. And then an answer plus a third-party complaint would be the defendant does the answer to the complaint, which is admit, deny, without knowledge, and then says, you know, this third party, you didn't even bring them in. It's all their fault. I'm going to bring in this third party because this third party needs to compensate for what happened. And that's essentially what goes on with responsive pleadings. Are there other types of responsive pleadings? Yes. A motion to dismiss means that we're trying to get the complaint thrown out. A motion for a more definitive statement means that the defendant or respondent looked at the complaint and says, I don't know what you want. I do not understand what you want. So please give me a little bit more information so I can appropriately respond. And there are obviously other types of responsive pleadings, but the important thing to remember is just think 20 days so you get it done on time. If the last day is a weekend or a holiday, it rolls over to the next judicial day. And please hire an attorney. If you don't hire me, hire someone else. And there are some legal aid resources in the state of Nevada that can assist with a lot of pre-made forms so that at least the defendant is able to get something on record to assist them while the litigation moves forward. The last thing you want to do, meaning don't do it, is to throw it away and forget about it. Do not forget about it because that's going to lead to a lot more trouble for you. Please respond. If you can't afford to hire an attorney, look at legal aid, look at forms online, but please get that responsive pleading in. And the Nevada Rule of Civil Procedure to remember is rule number 12 as to the timing.